Okay, good afternoon, everyone, and thank you for joining us today for the webinar on the topic of damages for mental distress in personal injury claims. My name is Shalini Thomas, and I'm an associate at Strigberger Brown Armstrong's Toronto office, although at this moment, like many of you, I'm working out of my home office. So for those who may not be aware, SBA is primarily an insurance defense litigation firm. We have three offices, like I mentioned, one in Toronto, and our other two are in Kitchener-Waterloo and in London. We host these 30-minute lunchtime webinars about once a month, and our webinars are recorded. So if you want to check out any of our past webinars or even this webinar at a future date, please head on over to our website where they'll be available. We also have a mailing list for our upcoming webinars. So if you want to subscribe so that you're kept up to date, please email us and we'd be happy to sign you up. Similarly, if you do want a copy of my PowerPoint presentation today, so you're not scrambling for notes or missing a case's name, please do send me an email and I'd be happy to share a copy with you. Now, at the bottom of your screen, you'll notice a Q&A button, and you can use that to ask questions, which I will do my best to address and answer at the end of the presentation, of course, subject to time allowing for it. If I'm unable to get to your question or you think of a question at the later point, please don't hesitate to shoot me an email and we can definitely chat about it. So without much further ado, let's dive in because there's no time like January and our present circumstances to talk all about mental distress. So my goal today is to provide a refresher on the history of awards made for mental or emotional distress, and then also take a look at two recent decisions in terms of further guidance from the courts and the evidence that's discussed that would warrant an award, and of course the monetary range being awarded. So everything begins in 1978 with three cases from the Supreme Court of Canada. These cases are often referred to as the trilogy, and the names of these three cases are up on the PowerPoint. So the three cases together imposed as a rule of law in Canada that there is a legal limit or cap for non-pecuniary damages, which are also known as general damages, in personal injury cases. Mental distress is one of the general damages that can be claimed, along with others such as pain and suffering, loss of companionship, physical disfigurement, and general loss of enjoyment of life. The court identified the following reasons for setting a cap on the amount of general damages that can be awarded. So damages for non-pecuniary losses or general damages are not really compensatory because it's not like any perfect calculation of money can truly provide restitution for these types of claims like mental distress. The award for these types of claims, these damages awards, are supposed to represent a provision of more money to make the plaintiff's life more endurable in light of what they endured or went through. So, the law does require that plaintiffs are fully compensated for pecuniary damages. And of course, those are damages that can be calculated and quantified, such as future loss of income, loss of competitive advantage, and future care costs. So an exorbitant award for general damages would lead to an excessive social burden. And as an example, the court pointed to the effect on there being no cap for general damages in the United States, particularly in the area of medical malpractice. And as a result, physicians in the states who are practicing have very high insurance premiums to compensate for these high caps, or rather no cap. So in that third decision there, in Tenno and Arnold, Justice Spence said, "We have a right to fear a situation where none but the wealthy could own or drive automobiles in Canada if there was no cap, because none but the wealthy could afford to pay the enormous insurance premiums which would be required by insurers to meet such exorbitant awards." So the trilogy ultimately sets that the upper limit for general damages is $100,000 save in exceptional circumstances. In the three cases listed here, the first one, Andrews, the underlying court decision had awarded $100,000, and that was upheld. And this was a plaintiff who was a young adult and went through a terrible injury that rendered him a quadriplegic. So this is already a fairly extreme injury, extreme case. So it does make you wonder what would qualify as an exceptional circumstance. Following the trilogy, courts across the nation began to apply the court's ruling, and some courts took the stance that inflation should apply to this upper limit. But it was a sort of gray area because the trilogy did not speak directly about indexing for inflation. So it was a legitimate question that needed clarification. And unsurprisingly, that issue returned to the Supreme Court of Canada in 1981 in the appeal of Lindahl and Lindahl. And in this decision, Justice Dixon confirmed that the 100,000 limit should be increased either upon proof or agreement as to the effect of inflation on that $100,000 amount over time. So today in 2021, but in 2021, the cap has been indexed for inflation to $410,256, just about $400,000. So it is not an insignificant award that could be made for those extreme cases. And then just moving back to 1995, the last decision there, Terknutzen, the Supreme Court of Canada again revisited the topic of a cap for the upper limit for general damages. And they confirmed that where a jury's award exceeds the upper limit, the court must step in and substitute its own award for general damages at the amount of that upper limit for the cap. And in our research, we actually did not find a reported personal injury case where that upper limit was exceeded by an exceptional circumstance. And I think that, you know, if and when that case does come, it would definitely be reported. So it hasn't occurred yet. But the argument has been made in non-personal injury cases that this cap that the Supreme Court talked about in the trilogy should also apply to other cases for general damages. But the court has disagreed. And when I say the court, as you can see on the screen, there's the British Court of Appeal, British Columbia Court of Appeal, and then two cases from the Supreme Court of Canada, where it was confirmed that there is no upper limit for general damages for cases for dealing with sexual assault claims, defamation, and negligence causing economic loss. Just briefly, I'll talk about the case of Young and Bella because it again discusses the policy reasons why there is a cap for personal injury cases. So in Young and Bella, this case involves a young plaintiff who was a university student. She was studying to become a social worker, and she submitted a term paper where one of her case studies referenced missed a footnote. And her professor speculated that because there was no footnote, this case study was actually a personal confession to having sexually abused children. He released that information to the Child Protection Agency, suggesting she was a suspected child abuser. And he also discussed his speculations and reasons for doing so with three other university professors in the program. He notified the RCMP, he notified a few social workers, and I guess a cherry on top was he also informed her boyfriend's sister. So the plaintiff ultimately commenced a lawsuit against both the professor and the university on the basis that they had forever tarnished her future career, her income earning capacity, and her reputation. And amongst other awards, the jury awarded her $430,000 in general damages. The Court of Appeal set aside the award, but then when it was appealed to the Supreme Court of Canada, they said, nope, there is no cap that should apply in these circumstances. when talking about why the personal injury cap would not extend to this circumstance, they said, it is the policy considerations which arise from negligence causing personal injuries in the context of accidents and medical malpractice which warrants a cap. They further said, this type of case has no impact on the public purse, so a cap is not needed to protect the general public from a serious social burden, such as enormous insurance premiums. So now turning to the two decisions that I wanted to talk about specific to mental distress awards and personal injury cases. The first one being Sadati and Moorhead, which is a 2017 decision from the Supreme Court of Canada. This case involved a plaintiff who was involved in 5 different motor vehicle accidents. The effects of the injuries from the first one left him with chronic pain. The defendant in this specific case, Moorhead, was the second accident in the series of 5. So the plaintiff sued all the defendants for negligence. He sought various general damages as well as past income loss. The trial judge specifically found that the second accident involving Moorhead caused the plaintiff psychological injuries, including personality changes and cognitive difficulties. And this was based on the testimony of his friends and his family, as opposed to any specific medical evidence. So there was an award of $100,000, and on appeal to the British Columbia Court of Appeal, the appeal was allowed on the ground that the plaintiff did not specifically plead or argue damages for mental injury or distress, and as well that he had not put forth any sort of expert evidence of a medically recognized psychiatric or psychological injury. So there were 2 grounds on which the appeal was allowed. So next, this went up to the Supreme Court of Canada, and they said they actually allowed the appeal. And to the first point of appeal, they said that in claims for negligence causing mental injury, it is sufficient for the pleadings to allege some form of such injury. It does not have to be a specific pleading. So in this case, the statement of claim said, the statement of claim claimed general damages for pain and suffering, loss of enjoyment of life, amongst other things. So this was sufficient to fall under the general pleading for mental injury. And then there was also actually an expert in this case who discussed the plaintiff's mental disorders, even though he did not specifically say that the mental disorders was related to the Moorhead accident, but there was an expert brought in on the topic. And then the plaintiff's oral and written closing submissions both made reference to him having a psychological reaction to the second accident. The court also noted that none of the arguments regarding the plaintiff's psychological, emotional, or psychiatric reactions to the accident elicited any objection from the defendants while they were at trial. And all of these things combined together provided ample notice to the defendants of the case they had to answer. So there was no breach of procedural fairness. As for the second point of appeal, this is what this case is most known for. The court made it very clear that Canadian negligence law does not require a plaintiff to prove a recognized psychiatric injury in order to be awarded damages for mental distress. So to this point, the court said, a trier of fact is not concerned with diagnoses. Diagnoses is relevant for the medical profession in terms of assessment and treatment, but it is not relevant for legal analysis. A trier of fact is simply concerned with the symptoms and the effects of those symptoms on the individual's life. So they went back to the standard negligence 4-part test that you may recall from the decision of Mustafa and Culligan. This is, of course, the fly in the bottle decision that set out that 4-part test, and I'll be discussing it shortly. But that 4th part of the test talks about whether it was reasonably foreseeable for the defendant to recognize that that sort of injury would occur to the plaintiff as a result of the negligence. So the court said the negligent defendant need only be shown to have foreseen injury. If they need not be shown to have foreseen a psychiatric diagnosis. The court also noted that we don't require plaintiffs alleging physical personal injury to show that their condition carries a certain diagnosis or a label or a high threshold. So it essentially would be unfair or discriminatory to require more of those alleging a mental injury. So turning now to that four-part test, just again, as a refresher, in Canadian negligence law, there is a duty at common law to take reasonable care to avoid causing foreseeable mental injury. And this recognizes a right we uphold in Canada to be free from negligent interference with our mental health. So in order to recover for mental injury negligence law, the court in this decision confirmed the same four-part test applies. The plaintiff has to establish a duty of care. They have to establish a breach of the standard of care. And then when it comes to damages, the threshold was set out in Mustafa. So the quote, and I will read it out, is that the law does not recognize upset, disgust, anxiety, agitation, or other mental distress that falls short of injury. Quite simply, minor and transient upsets do not constitute personal injury and do not amount to damage. Instead, the plaintiff has to show that there was a level of mental distress that had a significant impact on them or their life. The court confirmed that expert evidence can be used in order for the plaintiff to do so, but it is not necessary. And that the assessment is simply whether, based on the evidence presented, was there a mental injury on a balance of probabilities? Or did the negligence cause this individual mental distress on a balance of probabilities? The court said that defendants are welcome to bring in an expert to say the accident could not have caused any mental injury known to psychiatry for the reasonable person, but that has its own challenges, as we can imagine. And then for that fourth part of the test, a legal and factual causal relationship between the breach and the damage, essentially the court said compensation is required where the damage was reasonably foreseeable in a person of ordinary fortitude. And again, this harks back to Mustafa, and that the exception is where the defendant had knowledge that the plaintiff was a more vulnerable or susceptible individual. In that case, the ordinary fortitude requirement will not be held strictly, as in that case, the plaintiff's specific injury or the way they reacted would have been reasonably foreseeable to that defendant. So again, if you recall, harking back to Mustafa, this is the leg of the test that his case failed on, where while there was a factual causal relationship between the breach and damage, he wasn't able to establish that there was a legal causal relationship between the breach and damage. He was a particularly vulnerable individual, simply just based on his the personal level of cleanliness he ascribed to, and some of his religious background and the requirements his religion placed on cleanliness. So his reaction was definitely extreme and not of a person of ordinary fortitude. And there was no proof that Culligan would have been aware of it, and that's why that wasn't established. So now moving on to Moore, which is a key personal injury decision from 2021. Now this case is being talked about and famous for its commentary on FLA damages awards. So I'll briefly talk about that, but my colleagues Krista and Ariana actually did a recent webinar on this decision, which if you missed, I highly recommend going back and watching so you're up to date and well informed on that topic. So briefly, previous jurisprudence had given the impression that the high end of the accepted range for FLA damages was $100,000. and that was in early 2000s, so which when indexed for inflation would have been $150,000 at the time the award was made and more. But in this case, the jury actually awarded $250,000 to each respondent for the loss of care, guidance, and companionship. And on appeal, the Court of Appeal upheld this award and made it clear that there is no cap on damages for FLA awards, and the reasonableness of the award will be determined based on the facts of the specific case. So again, watch the webinar if you want to know more specifically on that topic. But for our purposes today, I'm going to focus on the award for mental distress made by the jury in this case, which was also $250,000 each for the two respondents. So before delving into the reasons for that award, I'm sorry, I should just mention the Court of Appeal also dismissed the appeal of that mental distress award and upheld it in this decision. So the facts of this claim are very sympathetic, are very compelling. So the plaintiffs in the case are a mom and dad, and they brought the claim following the very tragic death of their 24-year-old daughter, Alicia. At the time of the loss, the family lived in a basement apartment of a rooming house, which was owned by the defendant landlord and his numbered corporation. This was an individual who had many prior infractions for fire code violations. He had previously paid a fine of $75,000 in 2015 for these violations and had even been placed on probation for 18 months, during which he was not permitted to possess any rental properties. But here we were again with him owning properties and that he was renting out. And he essentially, was a dangerous landlord who created illegal housing and rented it out for his own profit. So on the day of the accident in this claim, a fire had broken out in the rooming house in the early morning. And Alicia at the time was still sleeping. There were no working smoke or fire alarms as is required by the fire code. And the landlord had barred the windows. So Alicia had no way of escaping out of the windows. And the only exit from that apartment was engulfed in flames and smoke. Now, the fire code does require there always being two exits from any room. But the second exit in this case, which was the interior access stairway connecting the apartment to the main house, was illegally blocked off. And of course, there was no fire safety plan implemented by the landlord as required by the law. So Alicia had to wait essentially for fire crews to arrive before she could be rescued. And when they did, they had to pull out her body from the apartment. She was unconscious. She had severe third-degree burns over half of her body, and several parts of her body had started disintegrating. The parents had to witness this. They also witnessed the first responders work to resuscitate her. She suffered 2 cardiac arrests on the ride to the hospital. And then the Court of Appeals decision talks about how she clung to life for a few days at the hospital while her parents essentially, sat vigil by her bedside. So she suffered further cardiac arrests while in the hospital, which again, the parents had to witness. And ultimately, they had to make the very difficult decision to remove her from life support when brain scans showed no more activity. So on appeal, specifically with respect to the award for mental distress, the landlord, who I should note represented himself on appeal, he argued that the damages were too high and were also incorrect as they were directed at the parents' grief. The Court of Appeal rejected this argument, and they said the mental distress claim was rooted in much more than the parents' grief. It wasn't just that Alicia died, it was the horrible circumstances of her death, everything they had to witness, the subsequent medical events, and of course, them having to make the terrible decision of removing her from life support and burying her. So in this case, the evidence put together, I think was, and of course the facts of the case are what led to the jury awarding the $250,000 each for mental distress. I believe a publication I read talked about how the parents' testimony was exquisite. There were also many eyewitnesses who also testified compellingly. And there was also expert evidence put forth in support of this claim. The psychologist testified that the mother had suffered a marked deterioration in her mood and daily functionality, and had also experienced passive suicidal ideation with with serious contemplation of ending her own life, while the father was now experiencing PTSD symptoms, which had become worse, with anxiety included. So, based upon all of that evidence, the court found no basis to interfere with the award of $250,000 in mental distress damages awarded to each respondent. So the takeaway, from this webinar essentially would be to not underestimate that a jury will take seriously claims for psychological and mental distress, and that a jury will possibly award damages for same, even if it's not explicitly pled. It's sufficient for a general psychological or emotional type injury case to be pled with evidence and submissions and testimony put forth. Expert evidence is not required for a plaintiff to prove this claim. And then, of course, the threshold is the standard negligence four-part test we discussed that was established in the Mustafa decision. So very simply, if there was a duty of care that was breached on a balance of probabilities, did the plaintiff suffer mental distress as a result of the accident or the negligence? And if so, would it be reasonably foreseeable for a person of ordinary fortitude to have suffered mental distress from the incident? What is the evidence of mental distress in this person's life? Is it significant? And if all of these check mark yes, then it is a live issue for consideration in your exposure analysis. And of course, keep in mind that the upper limit threshold is presently sitting at just over $400,000. The ranges awarded have not reached that amount in recent decisions. The Moore decision, of course, is quite tragic, and it was $250,000. So that does give us a sort of a gauge for how these awards are being made. But definitely something to keep in mind because it is an area that courts are taking seriously, and of course, juries are taking seriously as well. So that concludes our webinar for today, and I hope everyone watching it found it informative. I do want to highlight our next two upcoming webinars. On February 16th, my colleague Devin Marr will be talking on the topic of claims for employment wrongful acts, what liability adjusters need to know. And just like this one, the webinar will be at 12:30. And then again, on March 9th at 12:30 again, my colleague Laura Emmett will be talking about what to expect when you're expecting a claim. Oh, I see in the Q&A a message from Tracy DeCaro. Thanks, Shalini and SVA. You're welcome. Thank you all for joining us today. I see the time is 12:58 and we don't want to keep you more than your lunchtime hour. So thank you for joining, and we hope it was helpful, and we'll see you at the next webinar. Take care, everyone.